I'm thrilled with our wonderful moderator and panel tonight. I am going to introduce our moderator, Greg Musil. And then he will introduce the panel. Greg is a Kansas farm boy. He was educated at Kansas State University and the University of Virginia School of Law. He is an attorney. He worked on Capitol Hill with Senator Nancy Kassenbaum for 4 years before returning to Kansas and beginning his law practice. In 2013, Greg was awarded the Bar Association's highest recognition, the Justinian Award, based on integrity, service to the community, service to the legal profession, warmth, friendliness, and camaraderie. He currently serves on the board of directors of the Kansas Leadership Center, a statewide civic leadership effort. Greg has served on the Overland Park City Council from 1993 to 2001, including 2 terms as council president. He was elected to the Johnson County Community College Board of Trustees in 2011, was re-elected in 2015, and currently serves as the board chair. Welcome, Greg. Thank you.
Thank you. Can you hear me? It's working? It's a pleasure for me to be here tonight. I've been in my various roles as a city council candidate and a Johnson County Community College trustee candidate and a candidate for Congress in 2000. I'm usually on the answering end of questions from League of Women Voters panels. So this is going to be fun tonight to get to ask the questions. And I really appreciate my former partner, Andy DiMaria, not laughing at some of the characteristics of the Justinian Award. At least not laughing out loud. Thank you very much. It's a pleasure to be here. The League of Women Voters is a critical support group for what I consider to be Kansas and American democracy, because it's dedicated to making sure people know how to register to vote, and then actually ask questions and think about both sides or all sides of an issue and a candidate before they vote. And if we don't do that, then we're going to get more of the same. And I think we can do better. So I really appreciate all of you who took time out tonight. I do understand, Judge Tatum, that we'll be out of here in time to watch most of the KU game.
Go Jayhawks.
We're here because you have an interest in the Kansas Judicial Branch and the judges and courts in Kansas. The panelists up here have that same interest. That includes not just judges, but the personnel that support them, their administrative assistants, their court reporters, their law clerks. And the system of justice in Kansas affects more than that. It affects certainly lawyers who represent parties in court. It affects district attorneys who are trying to prosecute crimes. It affects families trying to figure out who's going to take care of their children in a divorce or children who have been abused. All of those people have an interest in our court system. And unfortunately, at times, it appears that other parts of our government don't seem to have that same interest. I thought I'd start with a story tonight. It happened in a courtroom in Kansas, and they were getting ready to have a trial to the court. The judge was going to make the decision, and the 2 lawyers are there starting in the morning. The judge comes in the courtroom, and the plaintiff's lawyer looks up and sees the judge and runs up and says, "Judge, I understand you have a favorite charity, and here's $100. I'd like a $100 bill. I'd like you to give that to your charity." And the defense attorney sees that, and he runs back up with 2 $100 bills and gives them to the judge, says, "Judge, I really want to support your favorite charity." And the judge looked at the defense counsel and said, "Here, take $100 back. I'm going to try this on its merits." Now, I don't think that happens anywhere in Kansas. But I use it to illustrate the impact if a court system, a judge, is not fair and impartial to the litigants in front of them. If a judge is not fair and impartial as to the lawyers in front of her. If there's some outside influence or pressure that imposes upon that judge even a thought that I should rule for A or for B because it is more politically expedient, it will help my funding sources, it will help me get retained or reelected. And that, I think, is what the league has fought hard for over the years, is to ensure our courts remain fair and impartial with some independence. And that's what I think we'll talk about tonight, about what the challenges to that and how we might do it, and whether there are improvements that we can make in our court system in Kansas. We have three outstanding panelists tonight. The first one is Professor Jeffrey Jackson. He's a constitutional law professor at Washburn Law School. He graduated from Washburn undergrad with a BBA in economics, and then from Washburn Law School. He then, for some crazy reason, went on and got his LLM, his advanced degree in law and constitutional law from Georgetown Law Center in 2003. He has staff experience as an attorney for the death penalty and constitutional issues with the Kansas Supreme Court, as a law clerk to the Chief Judge of the United States 10th Circuit Court of Appeals in Denver, which is the circuit court that has jurisdiction over Kansas. He served as clerk to the Honorable Mary Beth Briscoe, who was the Chief Judge of the Kansas Court of Appeals before she was elevated to the 10th Circuit. He has also served as law clerk to Kansas Supreme Court Justice Robert Davis. Interestingly, he's also been in private practice, so he's seen it from about every kind of aspect that you can. He now teaches constitutional law, comparative constitutional law, constitutional history, and legal analysis, research, and writing. Please welcome Professor Jackson. Our second panelist in the middle is Judge Steve Tatum. Judge Tatum is a retired judge from the Johnson County District Court, although he still serves on an interim basis as a pro tem judge. He graduated from Missouri State University and taught high school for 3 years before attending Washburn Law School and obtaining his law degree. He then served as an assistant district attorney in Sedgwick County, Wichita, and served as head of the trial division in that office. In 1978, he moved to Johnson County and joined the district attorney's office here, where he served until 1989. He also has experience in the private sector, having spent 5 years in the Sprint trial division as in-house counsel for Sprint Corporation before he was appointed to the Johnson County District Court in 1994. One of the issues we'll talk about tonight is the chief judge of each district in Kansas, and Judge Tatum served as chief judge in Johnson County from 2002 through 2008. He's active in the community as a member of the United Community Services Advisory Council, and he serves on the Johnson County Criminal Advisory Council, where one of his primary efforts is working with the Changing Lives Through Literature program for those who are caught up in the criminal justice system. Welcome, Judge Tatum. And finally, Micah Kubic is with us tonight. He is the executive director of the Kansas chapter of the American Civil Liberties Union. Micah attained his PhD in public administration and black politics, along with a minor in political theory from Howard University in Washington, D.C. He's been involved in the fight for civil liberties since high school and has a passion for issues of civil liberties and racial justice. Before becoming executive director, he served as a director of planning, development, and evaluation for the Full Employment Council in Kansas City. Welcome, Micah. We have a lot of topics to try to cover tonight. As was said, if you have questions, please write them down on your pads and raise your hand or pass them to the sign, and we'll see if we can get everybody's questions in. We will probably try to wrap this up around 8:30, probably an hour and 15 minutes, maybe enough of this, unless we're really going strong and everybody's happy. Coffee and drinks, if you need to get up and go get coffee or get a cookie, please feel free to do so. I told the panelists we'll start with kind of a softball and kind of a general question about in U.S. and Kansas constitutional history. Give us a nutshell description of why three branches, why checks and balances. What are we doing in our branches of government, both at the federal level and the Kansas level?
Can everybody hear me okay?
No.
Testing.
Let me take a few seconds to work on it.
How many lawyers does it take to turn on
Tap on it, yes. No. Try the other one.
We'll just pass that one. That one was one. All right, we'll just do it this way. All right, so it's an interesting kind of idea that we end up with three branches of government, but that's really the governmental plan that the Constitution sets out. Part of it is that under the English Constitution, which is kind of where we got all of our stuff. They are basically a two-branch constitution, king and parliament. And there was this idea that there are some things in the English Constitution that you just didn't do. But there was no, they had courts, but the courts didn't have the authority to tell you that anything was unconstitutional. So it's kind of like the old saying, you know, when the British bobbies didn't carry guns, it was that, stop, or I'll yell stop again. And so that was one of the things that actually the framers were of the opinion that it was a bad idea to leave either of the other branches unbounded. And so we ended up with a court system. And if you look at what the framers did, they weren't terribly clear on how this judicial review thing was going to work, but it's fairly certain that most of them thought that, in fact, there would be some sort of judicial review in this third system. So they have three branches, but the three branches aren't separate branches. That is, they're distinct, but there are give and take among them. And that's kind of the big thing. The theory, the best plan would be to have some give and take among all three branches, but have each branch armed with the ability to protect itself from the others. So there are checks and balances among each of the branches because of that, and for that reason. And so that's the kind of system that they tried to write into existence, where you would have those checks and balances if everything was operating properly. And that's the kind of system that they bequeathed down to pretty much every state then that was formed after the Constitution, which is how we ended up with that in Kansas.
Is there any fundamental difference in the Kansas Constitution and that of the federal Constitution as far as those three branches?
Pretty similar, set up about the same. And I think one of the things that goes on all the time between the three branches is deciding who gets to do what. And you can watch that on the national level. You can also watch it right now on the state level. My job tonight will not be to talk about the pending litigation. I'll let these two persons give you information about that, because since I do pro tem, I'm not allowed to talk about pending litigation, so I'm going to stay away from that. But I will talk about how we select judges here in Johnson County, how the Supreme Court justices are selected, and also just a little quote, if I could, in the co-equal branches, right? So what did the founders intend that each branch should do? Well, here's what James Madison said about when he was in the process of introducing the Bill of Rights. He said this to the House of Representatives: independent tribunals of justice will be an impenetrable bulwark against every assumption of power in the legislative or executive branches. I think there's a real role for the courts.
Let me ask you this, though. What stops the courts today, either the Kansas Supreme Court or the U.S. Supreme Court, from assuming that same power? What are the limitations that are in the Constitution on the court?
Right, so the courts actually have a number of limitations on them, some of which they actually impose among themselves by custom. But the ones that are in fact imposed, one of the biggest ones is actually the idea of case or controversy. And what case or controversy means is that courts don't get to just decide things. They don't get to give advisory opinions without a case in front of them. So what they have to do instead is they have to decide cases that come to them, cases that get filed in front of them. So it's one of those situations where the court really isn't equipped to be tyrannical, to grab a whole bunch of power, because they actually have to have a case in front of them. And so they worry about things like that. There are other things that we talk about in Common Law 1, such as standing. They have to have real injury before you can bring a case in court. So there are a lot of limits in that regard. And the courts are also ultimately bounded by some different limitations that the Constitution provides. For instance, there is a provision for the impeachment of judges at the federal level, in the same way that there are provisions here at the state level for judges who are on what we call commission selection systems for retention elections, right? So there's accountability built in to each of those systems. And among other things, there are the roles of the political branches in appointing judges, and even to a certain extent, one of the big things that people are surprised to figure out is, I always ask my first-year constitutional law people, how many judges are there on the U.S. Supreme Court? And of course everybody gets 9. I said, how many judges does the Constitution say there have to be? And of course the answer is it doesn't. It doesn't specify it at all. And so there are all sorts of different mechanisms whereby both Congress and the executive have some ability to control the courts in order to keep everything in balance.
And then ultimately, if the political branches don't like what the court ruled on some constitutional matter, they have a political response.
Oh, sure, you can always change the Constitution. That's kind of the easiest thing to do in that sort of situation. Not easy to do in that regard, but it's one of those things where the ultimate authority is not in the courts.
So I think, is this one working now?
No,
Temporarily. So I think the only thing that I would add is that, of course, I think the Constitution of the United States has 2 major purposes. The first, of course, is to sort of lay out the structure of government, how things are going to work, how things should work. But second, the Constitution and the Bill of Rights are designed to protect the rights of individuals in this country. Spells out the rights that belong to us, not all of them, because of course the Bill of Rights also says that some of the rights that are not included are retained by the people, but the Constitution exists to protect rights. And that goes back to the point that was made before, that the Constitution is really a product of the historical experience of the Founding Fathers and the tyranny that they perceived from England at that time. And so they consciously took steps to protect rights in a way that they had not been protected before. And so the Constitution divides the powers among the groups, not just for purposes of transparency or accountability to one another, but for purposes of accountability and protection of rights to and by and for the people. And each of the branches of government has different powers and is able to intervene in different ways under the assumption that at some point or another, one or more of the other branches is going to do something really lousy for your rights. And the only way to protect against that is to make sure that the other branches have other powers to be able to intervene and stop or correct that sort of thing. But at the end of the day, I would say that the separation of powers exists because your rights have to be protected. And the Constitution does that in a way that it had not been done before and still has not been done in a better way anywhere in the world.
we have 2 really smart people up here tonight.
3.
And one judge that's had quite a bit of experience. So what I would encourage you to do is write out those questions, because ultimately we want to answer the questions that you have on your mind. And so by writing out those questions, Greg will get those and he'll pose those questions to the panel.
Actually, Judge, this is one time you have to answer my questions. We've talked a little about the limitations that the Founding Fathers, or that the limitations they put on the court. So the Supreme Court, none of the branches can take over. What mechanisms did they place in the Constitution to make sure that courts had a level of independence and didn't just have to say stop and stop again to the political branches?
Well, the Constitution's pretty specific that the area that is given to the courts to litigate cases, to determine constitutionality of the Kansas Constitution. Those sorts of things are given to the courts. It's enumerated, it's very clear, and those are not to be impinged upon. So we do have the authority to give orders and make the orders that are appropriate with a case or controversy in front of the court that needs to be followed ultimately, if they're appropriate and right, by the legislative and executive branches.
Under the federal system, and when the Founding Fathers created the Constitution, they gave judges lifetime tenure once they were appointed. What was the purpose of that?
No, part of that was the independence idea. The idea that if you have lifetime tenure, then you are not beholden to any group. Because one of the things that the framers of the Constitution were most afraid of was this idea of factionalism. This idea that there would be political pressure brought to bear on the judges, and so they built in safeguards to make that actually work. Now, in Kansas, we've experimented with some different ideas with regard to that. That is, if you think about the different systems we have in place in Kansas for selection of district court judges, and then for Supreme Court, Court of Appeals judges, historically we have tended toward a little bit more accountability. Now, to a certain extent, that does cut into judicial independence a little bit, but it's a balance that I think, on the whole, we've chosen as a state to kind of strike in that regard. So I think accountability is probably good, so long as, because when you're creating some kind of system for judges, you need to get the right recipe, because you need to have the right proportions of different things. And so accountability is good, but independence is also vital. So you need to have accountability to the point where you can actually get rid of a judge who is not actually performing his or her duties. But at the same time, you don't want judges scared of being thrown out of office for a politically unpopular decision. It's a hard thing to get right. We've done pretty well here in Kansas with that, I think.
That's a good segue into topic number 2. Kansas, if I remember right, when it adopted a constitution, elected its Supreme Court judges, and that was the recipe we used until about 1958. Somebody want to tell us about what happened then that led us to a different method of selecting our justices?
Well, it was a triple play, and if I started to go into it, I'd probably get it wrong. But it resulted in a constitutional amendment which allowed the courts either to have what we call now merit selection, the Missouri plan, if you will, and we'll talk about that a little more, or to have elected judges from that point going forward, and it's been that way since that time. This has resulted in our 31 judicial districts, and I have a map here. If you would like to see it or get a copy of it, you'd be welcome to it, of our state being pretty much equally divided between election of judges and merit selection of judges. I don't know if you can see this at all, probably can't, but you see the big white areas in the western part of the state, you see that? Those are ones that are elected. You see the darker gray back to the eastern part of the state, and that's just a general statement because there's some odd other places there, but those are the merit selection places. You see a lot more along the eastern side of the state. And in Johnson County, we have merit selection. The Supreme Court of the state of Kansas has merit selection constitutionally, and I'll be happy to discuss that in some more detail a little bit later about how that works. I would mention this at this time. In the next election, this coming next November, there are 5 Supreme Court justices who are up for retention. Our Chief Supreme Court Justice Lawton Nuss, Justice Carol Byer, Justice Marla Lukert, Justice Dan Biles, and Justice Caleb Stegall. Steve Rose wrote a column. He said that this is going to be a big issue, big push, he thinks. To quote him, he says that the legislature has declared war on the courts. And I'm quoting what he said. So, but that's something that I think we're here tonight to think about a little bit and talk about.
We're going to talk about that retention election later and some of the other challenges to judicial independence. But Kansas Supreme Court, 7 justices selected by a merit system. An 11-person nominating commission sends 3 names to the governor. The governor has to pick 1. That's the constitutional provision adopted by the state of voters of Kansas in the 1950s. Right. Court of Appeals, by statute, was changed from that same merit system to a gubernatorial appointment and confirmation by the Senate 2 years ago, so that the Court of Appeals, and I should know exactly how many judges are on there, 16? 14 judges on our Court of Appeals, now are appointed by the governor and confirmed by the Senate. And then our district courts around the state, as you pointed out, are split. Some are elected partisan, you run as a Republican or Democrat for judge, and others, like Johnson County, are a merit selection system with, I think there are 14 people on the committee, 1 appointed by each of our county commissioners, and then 7 other attorneys elected by attorneys in Johnson County, and they recommend 3 to the governor, and the governor picks 1. So we have 3 different selection systems for the 3 different court levels in Kansas, and at the district court, the trial court level, where you will have your divorce trial or your automobile accident or your med-mal case tried, those are elected in different ways depending on counties. Sedgwick County, Wichita, Wyandotte County, Kansas City, Kansas, elect their judges on a partisan basis. Johnson, Shawnee, Douglas, the other urban counties are merit selection, and then, as the judge pointed out, a lot of the rural counties, a district might encompass 10 or 12 counties, and they're elected. What's the problem with, what are the problems that have been identified with the merit selection process by those who don't like that process? I'm not asking you to endorse it, but what are the...
Well, I think one important note to also make about the merit selection process, and most, but I think in all of the places where we use merit selection in Kansas, there is also an election later on. There is a retention election periodically where you get to vote yay to retain the judge or nay not to. There are more than one candidates for the position at any given time, but there is an election to either retain them or kick them out. So there is still an accountability provision in place there. I think some of the folks who disagree with the merit selection process have argued at various times that attorneys have too much influence over the process. Sometimes they've said attorneys have too little influence over the process. Sometimes they argue that the retention elections are too frequent, sometimes not frequent enough. Sometimes that there are too many layers of bureaucracy built into the process, it's too complicated. Sometimes they argue that the governor or the chief executive in any state ought to have the same powers that the president does in the federal system to name judges. And sometimes they simply argue that there is not enough accountability, that even though there is a retention election, not much really happens in terms of judges being dismissed as a result of that process, that there's so little involvement or engagement by the public to know what judges are doing, whether they're doing something right or wrong, and that the standard should be different. I see Senator Petty in the audience today, and she can tell you that some crazy things happen in the legislature. But I have to tell you, my personal favorite crazy thing that happened in the legislature this year didn't actually happen. It was a bill that was introduced that would have changed the retention election formula. So right now, if you get 50% plus 1 of the vote, you are retained. Because, well, that's how democracy works. The person with more votes rather than less wins. This particular bill that was introduced would have changed the formula so that you had to get 60% or more of the vote to win. So if 59.9% of the people wanted that judge to be retained, still loses. Still loses. I said, that's fine, we should do that for all elected officials then.
So the question that's raised in all of this, I think, is that independence of the judicial branch of the judges, but also who would you think would make a good judge? I mean, people argue if you elect judges, you can elect that person that you want on the bench, and if you have a merit selection system, maybe you can't do that. And in reality, does it work out that way or not? So what are some of the characteristics you'd like to see in a judge if you walked into the courtroom? What are those characteristics? Now, I have a list. And you can add to the list. That person has a legal, judicial background, the proper educational background, graduated from law school, a good character, have good ethics, a judicial temperament. They're going to be pleasant in the courtroom to all the parties. Fairness, perhaps, in that. Disciplinary record, have they had any problems with any unethical behavior? And what about their service to the community? Are they community-minded? Is that important? How about their impartiality, both parties when they come into the court? How about the respect of their legal colleagues? Is that important? Are there other things that you would add? There might be, and certainly raise your hand or send a card up. That'd be great. So we think about those things. In my experience, and I had 5 retention votes, by the way, yes or no votes, in my career, 20 years on the bench. And the Bar Association evaluated us, and we made those public. Then the state, for a while, evaluated us and made those public. And our courtrooms are always open to the public, so they can walk in and watch us. In my jury trials, I always did a little questionnaire once the jury was completed their duties, and they could fill it out if they wanted to, and give us feedback on how they thought the court did, how the judge did during that trial. So we had a lot of feedback, and which I think is important and certainly helped me a lot through the years. And here's another truth about at least what I've seen with the merit selection system. We get those applying for the position through the merit selection system who have had years as a lawyer, have built a solid practice, who are well respected in the legal community. They don't come along at age 30, usually, 35, 40. It's usually when they're in their 50s or maybe in their 40s. And they've built in the community, a legal community, the respect of their colleagues. So when they go through the merit selection process, they have something real and tangible to offer. I compare our merit selection system a little bit like this. If you were on the board of the KU Medical Center and you were going to hire an orthopedic surgeon, who would you want to sit in the room to evaluate and decide who would be the person that you could hire for that job? Because when we have 7 lawyers in Johnson County, 7 members of the community appointed by each of the county commissioners, and they study and they look into those persons' background, legal writing, all kinds of considerations, then they make their decision and pick 3 of those names, all very well qualified to send to the governor for the final decision. When I applied, when I went through that process, my neighbors came over to me during that process and said, hey, the KBI was here. And what's the problem? You know, what are they looking for here? They were asking about you. So it's a pretty thorough vetting process. That's what I'm trying to say, to get to that point where you might get your name sent to the governor.
One of the things that has been a point of criticism of the merit selection system is that it isn't transparent enough that the merit nominating commission deliberates in private. But compare and contrast that to the process we've seen the last couple of times when a Court of Appeals judge has been named by the governor and approved by the Senate. Compare the transparency portion.
Well, it's pretty easy to compare the transparency portion. in that regard, because obviously the governor's last two selections haven't been transparent at all, in that we don't know who the governor was even considering at any point in time. In fact, no one knew until right at the end as far as the appointment goes. It's been kind of interesting. I always laugh. People say that a lack of diversity is one of those things they worry about with merit selection sometimes. That is, oh, the lawyers will just pick somebody insular. I think it's interesting that the governor's two selections both went to the same college in Pennsylvania, I think. That's not a very big college. It's amazing how that works. Harking back to kind of the criticism, and this is where I get to be a little bit different, I think, than my colleagues. So the main criticism that we've got for merit selection, at least at this point in time, is this idea that it is controlled by the lawyers. That is, it's controlled by members of the Kansas bar. And part of that is this idea that when you look at Kansas's particular merit selection system, there are 22 states that use merit selection. And yes, Kansas is on the extreme end in that we basically have 5 members that are
Normal.
Selected by the bar, and four members that get appointed by the governor. And so there's the idea that maybe that ought to be changed. And I will say this, there is a little bit of a point to that idea. That is, it's not one of those criticisms that you can sit there and say, oh, this has no basis at all, because in fact it does.
The point being, if the 5 lawyers band together for one candidate, they can overrule the 4 citizens.
Right, except, of course, as anybody who's tried to get 5 lawyers to band together for anything would know that that's not one of those easy kind of situations. But among the 22 states that do have merit selection, Kansas is on the extreme end in that regard. So it's something that we maybe ought to take a little bit seriously. It's not terribly extreme. If you look at Indiana and you look at Alaska, they're very close to ours. It's basically even on both sides, and then a sitting judge, like a chief judge, who will make kind of that tie-breaking vote. So there are ways to even if the criticism of the current merit selection is in any way valid, there are ways to change that round a little bit. I think you don't want to get in a situation where any one person is controlling the whole system. But I mean, I think it's one of those, I think that's a system, that's a criticism that we probably ought to take a little bit seriously, is this idea that it's not maybe a perfectly designed system.
For educational purposes, Supreme Court justices in Kansas run for retention every 6 years, Court of Appeals judges every 4 years, and district court judges every 4 years in merit selection. If they're in an elected district, they're up for election every 4 years. I'm going to move on. I want to know, what is all the hullabaloo about now? Why are we in this situation now where there's such an amount of animosity and attention to the courts? What's driving this? Micah? In 1912, I just finished reading Bully Pulpit. In 1912, Teddy Roosevelt ran against judges and courts all over the country because they wouldn't do what he thought his policy was right. In the 1930s, his cousin FDR tried to pack the court so he could get a majority. Is this just more of the same? What are we worried about?
Yeah, of course. It's the oldest song in the hymn book. For as long as the Supreme Court has existed in this country, it has made decisions that some people disagree with. And so every time decisions come down that people disagree with, rather than challenging those ideas on their merits, rather than trying to build the popular support in communities around the state and around the country to change things substantively, people always want to game the system. That's what it's about. It's about gaming the system. I, for example, don't really particularly care all that great deal about merit selection versus election versus federal system. I don't actually have much of a position on any of those. I think you can make any of them work at one level or another. But what makes me deeply, deeply skeptical about people who claim that we need to change the system because of procedural flaws is that they all seem to be ticked off about the same thing. And they all seem to be ticked off about the fact that the court hasn't ruled in the way they want it to. If that's your issue, then say so. Don't be dishonest. Don't be disingenuous. Don't claim that it is a systemic structural problem, when in fact what it is an ideological problem. Disagreeing with decisions that are handed down. And so I think that's why we see all of the hullabaloo right now, because people don't like the decisions that are being handed down. You can disagree with the decision all day long if you want to. Great. Fine. But you don't change the system. First of all, because the system exists in the way it does for a reason. We got to this point through a natural progression, not because somebody just plucked it out of the ether one day. And second of all, because I think people often forget that every side can game the system. No one is in power permanently. So if you're changing the system now to get the outcome you want today, be prepared for someone on the other side to do the same thing later on. That's a dangerous, dangerous thing, and it puts our rights and freedoms at risk.
FDR tried to pack the Supreme Court for a while when he was president. If you've read that or read about that, he was not successful. So I think your point's well taken.
Yeah, and I think it has ever been so. In fact, my students are sometimes amazed to find out that the very first instance of gaming the system occurred in the election of 1800. And then the run-up there when the Federalists, who were the people who, after all, many of them wrote the Constitution, in fact, attempted to game the system to put their own judges in power after they had already lost the election, but before the new Jefferson regime could actually come in, and that got us Marbury versus Madison, actually, that whole controversy. And I think really the problem that we have here is, I think, yes, the legislature disagrees with, I think, basically at least two decisions in particular, but it is more of a blind to this idea that those are two decisions they disagree with, but at the end, it does in fact all come down, I think, to power. Whether you disagree with or agree with how the Supreme Court ruled in either school financing or in death penalty cases mostly, I think the point is, I don't think those are really the issue. I think the issue is one of power.
Some commentators have suggested that the reason that so many decisions that are societal shifting come to the courts now is because the political branches aren't doing their job, aren't passing clear legislation, aren't leading. Is that part of what's going on in Kansas?
One of the prohibitions on my discussion tonight is that on pending litigation in Kansas, and I think that maybe is what he's going towards, the education lawsuit. I can't comment on that because it's litigation that's pending, so I'll hand the mic off.
So I think there is no doubt that the state and the country, in many respects, are at stalemate on many, many issues. And I think there's a political science theory that basically says that when you're losing or at stalemate, you try and widen the terrain. You try and widen the debate and bring in new people to argue it out in the hopes that by bringing in new people, bringing in new power brokers, you'll manage to settle the thing. I think that has a lot of validity, particularly in this case. But I don't think that it's really a formula for long-term success in terms of either resolving the issue or in terms of reducing the level of animosity that exists within the state and within the system. I think it's much better to hash those issues out on a community basis, through the elected branches, through the legislature, rather than to always defer to the courts to settle everything. For one thing, it really ticks people off, and that's what we're seeing now.
You want to comment on that?
Go ahead.
Well, there are a number of high-profile appellate decisions that will have to be made by the Kansas Court of Appeals and the Kansas Supreme Court, some as early as December. The Carr Brothers death penalty case is at the U.S. Supreme Court. The Gannon School Finance decision is back in front of the Kansas Supreme Court, as is the decision about who chooses the chief judges for each district court in Kansas. And then there is a major abortion statute being challenged at the Kansas Court of Appeals. Would anybody like to just explain the Carr Brothers issue, what the Kansas Supreme Court did and what the U.S. Supreme Court will be ruling on?
Sure, I can do that. One of my sidelights is I've done a lot of death penalty work, and I do a lot of death penalty discussion on this. And when you're talking about a case as volatile as the Carr case, it's kind of an interesting conundrum you get there, which is I don't actually agree with the Supreme Court's Carr decision. That is, with the Kansas Supreme Court's Carr decision. I don't actually agree with it, but I see how they could have gotten there. That is, I don't think that it's a product of, oh, these justices hate the death penalty, they're going to find some way to let them off. Sure, because in the Carr case, well, there's in the two Carr cases, the two big things that the Supreme Court's going to talk about have to do with this question of should the trials have been severed at the penalty phase. And I think that's one of those things that reasonable people and reasonable judges can look at and disagree with. That is, you have a situation where there's evidence introduced, and anytime you have two co-defendants, there's always that idea that if you try them together, then they don't get to blame each other. And it's hard for the jury to distinguish who's most at fault or if they're both equally at fault, and that can be damaging to their rights. And I think that's a perfectly valid point to take. In fact, I think the Supreme Court's decisions in the Carr case, and in fact in most death penalty cases, are perfectly valid points to take. Some I've agreed with, some I have disagreed with. But I don't think that there's any where I can sit there and go, oh, that's just a horrible decision. Because it's not. And part of the reason I think people talk about, well, all these death penalty cases get reversed, and I say, yes, that's true. It is true. Why? Because death penalty cases are hard. And more importantly, Kansas has not been doing death penalty cases for very long. I know it may seem like a long time, but the number of death penalty cases that Kansas has done, it's not unusual for states that have a death penalty to have those cases reversed. I mean, we tend to think of Texas as one of those states where, oh, look, they seem to be able to have a death penalty that seems to work. Well, yeah, you know what? The first dozen cases for them, those got reversed too. It's just that they've had a lot more practice at this than we have, which I think is, I guess, on the main probably a good thing for Kansas. I certainly don't think, it's a bad thing that we don't have very many death penalty cases. We don't have very many murders that reach that level. And actually, I mean, I always say that I'm a death penalty agnostic. That is, I don't think there's anything constitutionally wrong with the death penalty, and I don't think there's anything morally wrong with the death penalty, and I think the death penalty as we have it in Kansas is about as fair as you're going to get. But if you're going to have a fair death penalty, understand that it's hard. It is hard, and it's especially hard if it's a new death penalty, because there are just things that happen. Nobody knows the procedure. Nobody knows what's going to happen from point to point. So the Carr case is now up before the U.S. Supreme Court. I think there's a good chance they may reverse it. Does that mean that our Supreme Court was completely wrong? No, it doesn't. Because I think the Supreme Court, these are issues that just have to get hashed out. And I think to say that it's the product of, oh, the judges in Kansas just don't want to affirm death penalty cases, well, didn't they do that just a couple weeks ago with the John Robinson case? Part of that was that in that case, the district judge that tried it really almost bent over backwards to follow everything that the U.S. Supreme Court did, and if there was any kind of a problem, anything where we're unsure, because the U.S. Supreme Court has tons of rules in death penalty cases, but not a lot of guidance. I think it resulted in a trial that was as fair as it possibly could be. So I don't know, in the Carr case, I think that's one of those situations where people get mad. I understand the death penalty is a contentious issue, but I don't think there's anything that would say that our court's not doing their job.
Micah, let's hear from you on that, because the case law says you're entitled to a fair trial, not a perfect trial. But the Carr brothers are as despicable to human beings as anybody could ever imagine, who did horrible things. Why can't we get a death penalty on them quickly and swiftly and make it be a deterrent and get them off the street?
Sure. So, absolutely, first of all, I agree they are two of the most despicable people that you will ever find. But I would disagree with my colleague on the panel about the constitutionality and the morality of the death penalty. I think that the death penalty is an abomination, and I think that it is unconstitutional. I think it is cruel and unusual punishment, and I think that in many places, including in Kansas, the death penalty almost invariably fails to live up to our highest standards of justice and of fairness. We know that death penalty defendants many times, almost more than any other defendants in the justice system, suffer from inadequate counsel, from having errors committed throughout the case, regardless of where it is in the country. And of course, I think you always have to keep in mind that the death penalty is a final punishment. You can't take it back afterwards. And so if you're going to do that, you should be mighty, mighty certain, not only that the person did it, but also that you have the moral authority to pass that sort of judgment on them. And that is not a declaration that I, at least, am prepared to make. And I don't think that it's a declaration that our government should say that it is prepared to make.
Let's move on to the Gannon and the school finance decision, which is, Judge, I'm not trying to leave you out, but the school finance decision in 2006, I think it was, the Montoy decision was issued, where the Supreme Court asserted that the legislature hadn't funded K-12 education sufficiently and ordered a specific amount of more money. And now we're back with another case where they're looking at whether or not the Kansas legislature has funded K-12 education. First of all, why does the Supreme Court have any role in deciding how much we spend on educating our kids?
So that one's an easy one to answer. And it is the Kansas Constitution, Article 6, Section 6B. Now, and this is another one of those things maybe we disagree about, or maybe we could disagree about, but it says, the legislature shall make suitable provision for finance of the educational interests of the state. So my question, and this is the question that I don't think has ever actually been answered very well by the people who are upset about the Gannon decision, the Montoy decision, and about school finance generally. My question to that is, what do you suppose that means? Does it mean anything? Because really the question is, we could make it mean nothing. That is, we could look at it and say, yeah, it's in the Constitution, but we don't really have to do that. I mean, is it just a guideline? Is it if you feel like it, you could finance education? I don't think it is. I think it's dangerous to have things in your Constitution that are not enforceable, right? In constitutional law, we do have kind of an idea about that. We have these things called political questions. There are these ideas that there are some things that maybe aren't enforceable, and that's been kind of the argument with this. People have said it's very vague. It doesn't say what suitable provision for finance means, which is true, but I don't think it's vague enough that it's not enforceable. And if it's enforceable, if it means something in the Kansas Constitution, if it imposes a duty on the legislature to make suitable provision for the finance of the educational interests of the state, then who gets to pick that? Who should do it? Do we let the legislature do it? Seems to me kind of an odd thing. If we're going to impose a duty on you to do this, but you get to choose when you've done it. And that seems very odd to me. So if we want it to mean something, and I think we should want it to mean something, I don't think we have a choice but to say that the court's got to be the one to enforce it. Now, I guess the question is, are courts able to enforce it? Well, I mean, what do? We make courts enforce things all the time, right? How do they do that? Well, we take evidence. Courts take evidence gets presented, and the court makes a decision. That's what courts have ever done. And so to say, well, they shouldn't be the ones to pick. Well, who do you want to pick? I think that's a question that those people who are upset with the school finance decisions, I think that's a question they have not answered. So I guess the question, I can turn back around and say, does it mean anything? Do you want it to mean something? Because if it's going to mean something, then the court's got to have the power to enforce it. And that's what they're doing. We didn't have to put that in the Constitution. I mean, the federal Constitution has absolutely nothing about education in it. We could have put in the Constitution the legislature shall fund education in the amount they think best, or as they like. We could have done that. We didn't. We chose the language in the Constitution. The legislature shall make suitable provision for finance of the educational interests of the state. That's the language we chose. Either it means something or it doesn't. I think it does.
And by being in the Constitution, I think that was adopted in 1966, meaning at least 2/3 of the people of Kansas voted to put that in the Constitution. Any other comment on the school finance? I mean, are there portions of the Constitution that the legislature ought to just be able to decide for themselves, or the governor? Or is the whole thing subject to the court's decision as to what is right?
Well, I mean, I guess if you're talking about state constitutions, right?
Right.
And you're talking about, and to a certain extent, federal constitutions. Yeah, there are some questions that the court will stay out of. Mostly, those questions are ones where there just are no justiciable standards, because even a court cannot operate in a vacuum. That is, if there is no way to figure out what a suitable provision for education might be, then yeah, that's one where the courts defer on those sorts of things. I mean, there are things in state constitutions that courts won't enforce. Relating to education, the one that I always have my students walk through, in the Arizona Constitution, there is a provision for the University of Arizona. And it says that the instruction furnished at the University of Arizona shall be as nearly free as possible. And the Arizona Supreme Court has basically said, in that sort of situation, we just don't have any standards. We don't know what as nearly free as possible means, nor do we have any guideposts for figuring out what that means. But I think in the Kansas Constitution, we have guideposts. We can sit there and say, okay, there is a certain bottom level of financing that is suitable, that is enough financing. It doesn't mean that the legislature is bound to that exact amount. They can go higher, but there's got to be a floor. Because again, if there's not a floor, it doesn't mean anything.
let's go on to the other decision that's at the Kansas Supreme Court. And I think that the court has scheduled December 10th for argument on the issue of a statutory change in 2014 and readopted in 2015 that says the Kansas Supreme Court can no longer name the chief judge of each of our judicial districts, and instead those districts will decide it among themselves. So Judge Tatum, you were appointed by the Chief Justice of the State Supreme Court when you were Chief Judge, and now all the judges in Johnson County get together under the statute and, I guess, vote on who they want to be Chief Judge. That's a statutory change. What's the constitutional issue here?
Well, the issue is whether or not the chief judge is the chief administrator of the judicial branch. And if he is, then he would have that responsibility as well as the opportunity to name chief judges in all 31 of the judicial districts, and it's been that way for 50-some years.
Is there a constitutional basis for the arrogant, power-hungry Chief Justice to try to name all the district court chief judges?
I'll let our experts talk about that, but depending on how you want to interpret the language in the Constitution, possibly.
I'll read Article 3, Section 1 of the Kansas Constitution. Right. Section 1 ends, quote, "The Supreme Court shall have a general administrative authority over all courts in this state," period, unquote.
Right, I think the language is fairly, I don't know what language you could make that would be clearer than as it already reads. And I think for the last 50 some odd years, that is the way that everyone has interpreted that particular provision. That is the way the Supreme Court itself interpreted that provision when they were asked, not in the context of a court ruling, but when they were asked in the context of the statutory change. That was basically what they said, that was how that should be interpreted, that authority belonged to the Chief Justice and not to the individual courts. So the constitutional question is, does the Constitution say what its plain language does or not? And I think the answer to that is undoubtedly yes. And I think the answer is even more yes because of the motives behind the statutory change, right? I hate to keep on going back to what people feel deep in their hearts, right? But this statutory change didn't just come out of nowhere. It wasn't as though someone just suddenly said one day, oh, we should make the local judges decide that. No, the statutory change came because people were upset about the school finance rulings, and so the response to that was, again, to try and change the system, to try and challenge the way the Constitution works. And so that, to me, is a big red flag.
Right, so I think it's pretty clearly unconstitutional. It's one of those, if you ask any constitutional law professor who knows constitutional law, it is in fact fairly clearly unconstitutional. There's not really a lot of wiggle room on that one. It's very seldom that the entire constitutional law faculty of Washburn Law School is in agreement, but especially very seldom that they're in agreement with me, because they tend to coast a little farther left than I do, but we're all in agreement on this one. It's clearly unconstitutional, and to be honest, I can't see any reason to have such a thing unless it's actually a direct provocation to the courts, right? It's the, I'm mad, I want to do something to get back, I'm mad at what the court has decided, I'd like to do something to get back at them.
Well, let's take that.
And I think those are dangerous things.
Let's take that the next step, because in 2014, the legislature made the change. In 2015, the legislature passed the judicial funding bill, which included this change and included a provision that said, if any court strikes this district or chief judge decision down, all of the funding of the court system will be taken away. Any comments on that?
I think this is one of the most shameful things that I have ever seen in my life. I think it is atrocious. I think they should be embarrassed. I am embarrassed for them. Because I think first of all, it's clearly unconstitutional, I think. Second of all, I think it is hostage-taking and blackmail. I think it is an intimidation tactic to try and guarantee that they get the ruling they want. I think it didn't work, first of all, and I salute the judge who decided to defy the intimidation and still find the appointment thing unconstitutional. And I think it's much more important than just this one particular issue. I think a lot of what we have seen in the news about it has focused very much around the particular school finance decision that sort of kicked the whole thing off. But the fact of the matter is that if something like this is allowed to stand, where the entire judiciary is defunded if they get a bad decision, then the entire concept of judicial review, the entire concept of Marbury versus Madison, the entire concept of the separation of powers is dead. It's done. It's the whole ball of wax, people. It's over. Because I guarantee you, if it is allowed to stand this time, then the next thing will be if you have a voting rights decision that we disagree with, the judiciary is defunded. If you have a reproductive freedom decision that we disagree with, the judiciary is defunded. If you have a police accountability or transparency issue that we disagree with, then the entire judiciary is defunded. And I can't think of anything that is more dangerous to the very concept of democracy and the Constitution as we know it than that is. This is a serious, serious thing.
So now I'm going to argue with that? Okay, actually, I'm going to say that I have a slightly different view on the matter. Amazingly. So do I think it's unconstitutional what the legislature did in this regard? Do I think it's a violation of separation of powers? And I'm not at all sure that it actually is. Why do I think that? Well, again, the whole point of separation of powers is that different branches of government get to, they fight it out with each other in certain ways. And so I think it may, in fact, not be a separation of powers issue for the legislature to say, if you don't rule this way, we're going to cancel the funding that the legislature does. But I think the legislature needs to be prepared to live with the consequences of that. And there are at least two consequences. I've been interviewed on this topic a bunch of times, and I said that what this basically is a game of judicial chicken, basically. It's a separation of powers chicken game here. And that is, there are two things that can happen in this regard. One of them is that the court is an independent branch of government. And every state that has addressed something like this, people have said, you mean it's happened before? I said, not to this extent. Well, why not to this extent? Well, nobody's been crazy enough to do that. But there have been situations where, in fact, a state has failed to fund the judiciary. That is, they failed to pass a funding bill, or they've canceled some of the funding for the judiciary. In those states, almost unanimously, there's been an idea that the court can actually, in those situations, requisition money from the Treasury in order to keep functioning, because it is an independent third branch of government. So I think the court's got, the ability to do that sort of thing. Do I think it's good policy? No, I don't. I'm not at all sure that it's unconstitutional, but then again, nor am I sure that the legislature really knew what it was doing when it did that. That is, now that the bluff has been called, strangely enough, I haven't noticed that the courts have stopped functioning. Have you? I haven't seen any of that. I mean, by all rights at this point, things should have...
Well, we haven't gotten to the point of chicken yet, because Judge Solomon, who filed the lawsuit, agreed to allow the order to be stayed pending the Supreme Court.
Right, but
decision.
notice that the state couldn't get a stay fast enough. Right? Suddenly the very people who say, well, you know, we're going to cut your funding, we're going to destroy your funding, suddenly, once that becomes a reality, they can't get a stay fast enough. So I think it is, I mean, it's one of those situations where if the Supreme Court makes a final ruling on this, I guess we'll see. I guess it'll be interesting.
I'm interested then, if you don't think it's unconstitutional, if in summer of 1953, Congress had passed a statute that says, Supreme Court, if you rule in favor of that little girl from Topeka, we will cut off your funding, would that have been a different tale? And is it different because the U.S. Constitution is different? And Brown versus Board of Education would have ended up defunding the federal branch, the judicial branch?
Well, to be honest, they can't defund the federal branch. That's one of the...
They can't lower the...
One of the beautiful things that the Constitution says is that they cannot, in fact, lower the salary of judges or refuse to pay judges.
Right, but judges don't work in a vacuum. I mean, every judge in the federal system has law clerks and assistants and bailiffs and courtroom deputies and
right.
janitors that open the court. So I'm pushing back a little bit on the constitutionality issue. If they said, if you rule in favor of Brown and Brown versus Board of Education, we're cutting off your funding, constitutional or not?
Constitutional to the extent that they have discretionary funding. That is, they can't not pay judges, and they cannot not fund, because it's not only the judges, but they have an affirmative duty under the Constitution to fund the third branch of government. Now, the amount could be up in the air. They could have said, and I think that, to be honest, the federal Constitution makes a lot better protection for judges in those situations than in others. So the other problem is if the courts just say, no, we'll shut down for a little bit, then I think you have another issue, and that's another power the courts have.
Well, just for the history of this, maybe what preceded this particular bill, and I'm not going to venture any opinions on that bill, but we had a situation over a couple of years where we had furlough days for our staff because of inadequate budgets given by the legislature. You're right, the judges got paid, but our staff certainly did not, and they had to take time off. So that's historically what's happened. So this is not just a brand new thing, I guess. We'll see how it plays out.
We've got a couple other topics, and it's 8:20. I want to get to the retention election, Judge, that you mentioned earlier. In November of 2016, 5 of the 7 Kansas Supreme Court justices will be up for retention, meaning each of them must get 50% plus 1 in order to stay in office. The question will be, shall this person be retained? And the option is vote yes or no. Before we get into the anticipated politics of that, how would somebody in Kansas figure out whether or not they liked or disliked or wanted to retain or unretain a Supreme Court justice?
Actually, there's a lot of information about judges if you want to take the time and effort to look up the information. There's a website, and I think it has some information. You can get reports of any misconduct that may have happened or not happened and probably did not happen, or everything that our judges do, including Supreme Court judges, when they have oral arguments, are open to the public. And in fact, they broadcast those on the radio, have a podcast, and sometimes I think they've even had some television review of some of the oral arguments that they have. They've made themselves available to the public. They've conducted interviews. They've gone out around the state to different locations, and when they do, usually talk to the press and give the press some information. So in many ways, you can get a lot of information about our judges, and probably it's an area where we could do better and should do better. And maybe this will be the time, because of what's anticipated to be an effort by those who oppose those particular Supreme Court justices, that they'll have to step up the game a little bit and provide more information. They went through the rigorous process of merit selection. They've been retained several times. You can look at their opinions. You can read their opinions that they've authored. You can see what they've said judicially. So there are many ways that you can kind of get an idea of who's working for you in the Supreme Court.
What should the criteria be for these ladies and gentlemen looking at a judge? What do you think they ought to look for? Any of the panel members?
Well, I think that what you should look for is that you need to review a number of cases that they've written, that they've authored, to see if they have an even hand or are exhibiting some bias. I don't think you'll find they're exhibiting bias, whether they're following the law, given law, constitutional law, stare decisis, which is case law that's gone before. If they're applying the law in even hand, if they've given both sides ample opportunity to provide their arguments and give some credence to those good arguments that are made by both sides. If they disagree with an opinion, that they author a dissent that you can read and understand their legal reasoning for those particular cases where they've dissented. So in all those ways, I think you can get a good idea if your justice is doing a good job for you in the state of Kansas for the judicial branch.
Let's turn to the politics side of it, because Kansas hasn't really seen a true kick 'em out campaign. In November 2014, there was a last 2 weeks campaign against the two justices that were up related to the Carr brothers' decision, and postcards were mailed out, and their percentage of yes votes was dropped from about the mid-60s to 53% for those two justices. What is expected for this coming year in terms of challenge to those 5 justices that are up?
The numbers on the other 2 justices in the last election who were up last time were not high over 50%. They were close. 52%, I think, was the number that they got. Preceded by a history where it was 60-70% through the years. So that was a wake-up call, I think, and they'll have to be much more proactive to get their message out about who they are, what they've been doing for in undertaking the requirements of their job and their office. But the main thing, I believe, that gives us a good idea whether this state wants to keep those justices in their position for another 6 years is a big voter turnout. I think that makes all the difference, because the last couple of years, if you look at the elections, the turnout in Kansas has not been that good, and we all need to be encouraging our neighbors to vote. And if you have information for them, that's your opportunity to talk to them about it, one way or the other. So hopefully there's going to be a lot of press on this particular issue. You'll get a lot of information, and you'll have a good opportunity to make up your mind about a yes or no vote on those 5 justices next November.
Anybody else, Mike, any comments on that?
I would say everyone should probably clean out their mailbox now, because you're going to be getting lots of postcards about it. I think we should all prepare for the last 2 weeks of 2014 to go on steroids this time around and see a lot more of that. And I think there are some people who are prepared to spend a lot of money on this particular issue, on both sides, mind you, on both sides, both for retention and against retention. And you should expect to see, I would predict, the most active, vigorous campaign that the state has ever seen for a retention election. And in some respects, I think it will be much more like the partisan Supreme Court elections that you see in places like North Carolina than anything we have experienced here before. And you can make up your mind whether you think that's a good thing or a bad thing. I'm not saying either way. I'm just saying be prepared.
With respect to that, the last election, the last 2 weeks of November 2014 on the Carr brothers issue, the postcard suggested to voters that the Carr brothers were now back out on the street. I mean, that wasn't completely true, was it?
No, the jail doors still slammed shut and kept the Carr brothers in custody, and that's where they're going to remain, despite the issues that have gone on. And even if the Supreme Court should decide that the death penalty is unconstitutional, which I don't know what will happen on that, but one way or the other, they'll be behind bars.
And they can be retried on the death penalty portion of the case. They're still guilty, and they would be retried for the death penalty sentencing part.
Yes.
Right. The only question actually is death penalty or life in prison without parole. Those are the two options once you've been convicted of capital murder. So that's really the only thing left out there. So they're not getting out. I guess I'd hate to say one way or another, but in fact it is one of those things.
I'm going to go through some of the questions from the audience, and I'm going to go ahead and try to answer some of these, and then if I'm wrong, you can correct me. Did not the voters of Johnson County vote to retain the merit system in Johnson County a couple of years ago? That was actually 7 years ago, November of 2008, and the voters, over 59%, voted to retain the merit system instead of partisan political elections. That can't go on the ballot more than once every 8 years. So it could possibly be back on the ballot in 2018 if a petition drive is started as was done last time. It takes a lot of signatures. I don't know if anybody will undertake that again, but at least until 2018, we're on the merit system. What is the process to impeach a judge? I can't remember what I did with you, Judge Tatum. Did I get signatures, or what did I do?
You told me to retire or else, I think.
Do you know the process of impeachment, what the grounds are for a judge?
No, but if we have a judicial quals committee too, so if a judge is acting improperly, they'll take up the issue with the judge, and that often, if there's something that is serious, they'll encourage that judge that they need to get off the bench. Doesn't happen very often. It's very rare. But there is that process as well. But the ultimate process is impeachment. I would assume that would have something to do with the legislature.
When the names for judges in the merit selection system are sent to the governor, can he reject all three and ask for three more?
He can reject all three, but if he does, then the Chief Justice of the Supreme Court would select from one of the three.
This is a federal system question. In 1776, life expectancy was about 60 years. Now it's well beyond that. How has that changed the court with members staying for 40 or 50 years? Is that a good thing? And Kansas has an age limit, retirement limit. I think it's 75 in Kansas. Should there also be an age limit on members of the legislature? I didn't read that part. Talk about age limits for judges and maybe in the federal system, whether the lifetime appointment now goes beyond just judicial independence and maybe goes too far.
Well, how long should a judge stay on the bench? That's a very good question. And I retired a couple of years ago at age 69. Some might say that's too long or not long enough or whatever, but 75 right now is the number. Federal courts, they can serve out their life as a judge. In fact, we had Judge Brown down in Wichita. How old was he when he died?
He was 104.
He was still taking to the bench there shortly before he passed. So whether that's a good idea or not, but the idea that a person who is appointed under the federal system to the court has lifetime tenure certainly gives that person a lot of judicial independence. Now, under the merit selection process, I never raised any money during all of my 20 years, not a dime, from anyone, so that whoever came in my courtroom, the parties, the attorneys, I didn't owe them anything. I didn't owe them anything except to be fair and impartial, and it made it a lot easier for me to do that. Now, whether we'll be able to maintain that system, I hope we will, but I think your comments are good about what's coming up for Supreme Court justices, and we'll see how that all plays out. But the other thing that I would say, because you raised the issue of transparency very briefly, is that when they have a application process for selecting the names of three persons to send to the governor, those hearings, those interviews are open to the public. You can go there and you can listen and hear the questions that are asked. So it is very transparent.
Percentage-wise, what does it break down to men and women as justices on the courts? Let's start with the Kansas Supreme Court and the Kansas Court of Appeals. And then I think what they're getting at, is there any difference maybe between the selection systems when it comes to diversity on the bench?
So we have, on the Supreme Court, we have 2 women right now. On the Court of Appeals, I think it's 4. I'm just guessing they're 4 out of 14. In Johnson County, I think we have 7 now out of 23. So it's, we need more women on the bench. We need actually more diversity on the bench, but it is heading in that direction. So
I was going to say, I actually did a study on the differences, and in Kansas, actually, there's not a huge difference, at least nothing that's statistically significant, depending on whether you have a merit selection system or a election system. Nationally, there is some evidence, however, that just from other states, because Kansas, we don't have that many judges. And so it's harder to get any kind of really good data. Nationally, the suggestion is, in fact, that merit selection tends to do a better job of diversity in enforcing diversity, not only, gender diversity, but also background and racial diversity as well.
I want to go through a little bit the number of challenges that have been at least introduced in the legislature to judicial independence in Kansas, and see if you have comments on any particular ones. The ones I had listed was, we've talked a little bit about court funding and rule the way I want, or we will take away your funding. There have been efforts or legislation introduced to lower the retirement age of judges and therefore eliminate a bunch of judges that are on the court now that would have to retire. The judicial selection processes, changing it, getting rid of the merit selection system. Little movement on judicial salaries or court personnel salaries, and then increasing the percentage needed for retention. So instead of 50% plus 1, 60% or 65%. Have I missed anything about the challenges that legislators have come up with?
I think that's enough.
Is that? But if courts are not doing, and it usually ends up with the Kansas Supreme Court because that's the ultimate decision maker, is not doing what a majority of Kansans want, what's the recourse for those citizens?
Well, I think the first thing to keep in mind is that we should not expect the court to do what we want. I don't think that's the standard that we should hold the court or anyone accountable to. The standard should be, is the court following the law, and is the court upholding the rights and values of the Kansas Constitution and the United States Constitution. Those things are not always synonymous with what I want. And I think all of us, on all sides of the political spectrum, have to always keep that in mind. It is not about getting the decision I want all of the time. The court is not designed to be a policy-making body purely. It makes policy on occasion, but it is not designed to be the sort of undiluted, pure stream of whatever people want at that moment in time comes out on the other end. So I think you first have to change the framing of it, but then if you decide that the Supreme Court justices really are not upholding the law, really are acting as tyrants, really are defying the Constitution every day, then your option is to not retain them. I don't think, however, that all of these sort of little changes, and some of them big changes, are about changing the system to work better. They are about changing the system so that it generates the outcome that a certain group of people wants. And that's the reason that I disagree with them. Not because I actually, again, care all that deeply about whether we use the federal system versus the merit system versus some system that somebody has yet to invent. I don't care. What I care about is whether in the end we get good governance, and whether in the end we get a judicial system and a state that upholds our rights and freedoms and protects the law.
I'm going to make that the end of our forum tonight. And thank you all for coming, and help me thank our panelists for a great discussion.